Hello everyone, my name is Amit Jyoti. I'm working as an assistant professor with the O.P. Jindal Global University. I would be recording this module on behalf of my colleague Professor Nitin Gombar. In this module, we shall be discussing the regional human rights systems in Africa and the Arab world. Let's begin our discussion with the systems working in Africa. In 1981, the Organization of African Unity, which was established with the main objective to get rid of the continent from colonization and apartheid, adopted the African Charter on Human and People's Right, also known as Banjul Charter or the African Charter. The objective was to stand as the primary human rights instrument for the African continent. The OAU has since been replaced by the African Union. However, its legacy continues to contribute to the human rights protection systems that were created under its aegis. The African system, like the Inter-American system and the European system as they were originally designed, is composed of two entities. One, a commission, and two, a court. These entities are tasked with the interpretation and application of a number of regional human rights instruments in addition to the Banjul Charter. Some of these are African Charter on the Rights and Welfare of the Child, Protocol on the African Human and People's Rights Code, Protocol to the African Charter on the Rights of Women in Africa. Next, Convention on the Prevention and Combating of Terrorism of the year 1999, Convention for the Protection and Assistance of Internally Displaced Persons 2009. Now, let us discuss the role and function of the Commission and the Court specifically. First, we would discuss the African Charter on Human and People's Right, or as known as the Banjul Charter or the African Charter. The Banjul Charter was adopted in 1981. Since then, Africa has experienced scores of human rights catastrophes of extreme proportions. The extreme poverty, the HIV/AIDS pandemic, and the 1994 Rwanda genocide, the Darfur crisis, and civil wars in Somalia and Syria, among others. Through these tough times, the Banjul Charter has stood the test of time and has helped steer Africa from the age of human wrongs into the new age of human rights. The Charter sets standards and establishes the groundwork for the promotion and protection of human rights in Africa. The Charter has also dealt a big blow to state sovereignty by emphasizing that human rights violations could no longer be swept under the carpet of internal affairs. Therefore, no one can only imagine what the continent would have been without this particular charter operating in the territory. Accordingly, let me now give you a brief overview of the provisions contained in the charter. We would be touching upon only certain articles and not all. Article 2 provides every individual shall be entitled to enjoyment of rights without any distinction of any kind whatsoever. Article 3 says, every individual shall be equal before the law and every individual shall be entitled to equal protection of law. Article 4 reads, every human being shall be entitled to respect for his life and the integrity of his person. No one may be arbitrarily deprived of his right. Article 5 says, the inherent dignity of every human being must be recognized. All forms of exploitation, degradation of man shall be prohibited including torture and slavery. Article 6 says that every individual shall have the right to liberty and security of his person. No arbitrary arrest and detention can take place. Article 7 says every person shall have a right to an appeal against violation of fundamental rights, right to be presumed innocent until proven guilty, right to be defended by counsel of own choice, and the right to be tried within a reasonable time by an impartial court or tribunal. Further, Article 8 says everyone to have the freedom of conscience, profession and free practice of religion subject to law and order. Article 19 says every person to have a right to express or disseminate his opinions within law. Article 10 says every individual to have a right to free association provided he abides by the law. Article 11 says every individual to have a right of free assembly with others subject to necessary restrictions placed by law. Article 12 says every individual to have the right to freedom of movement, right to leave or return a state subject to restrictions placed by law. Mass expulsion of non-nationals to be prohibited. Every individual under this article has a right to seek asylum when persecuted. Article 13 says that every citizen will have a right to participate freely in the government of his country and have the right to equal access to public services and public property. Article 14 says that everyone has the right to property. It may be encroached upon in interest of public need or in cases of general interest of the community. Article 15 says that every individual shall have the right to work under equitable and satisfactory conditions and shall receive equal pay for equal work. Article 16 says that every individual shall have the right to enjoy the best attainable state of physical and mental health. Article 17 says that every individual shall have the right to education, to have his moral and traditional values protected, and be able to take part in cultural life of his community. Article 18 says that state shall ensure that every family is protected, discrimination against women is eliminated, and the aged and disabled have the right to special measures of protection keeping with their needs. Article 19 states all people shall be equal, they shall enjoy the same respect and shall have the same rights. Nothing shall justify the domination of a people by another. Article 20 says all people to have the inalienable right to self-determination. Colonized or oppressed people to have a right to free themselves along with the right of assistance from the state parties. Further, Article 21 says that all people to have a right to freely dispose of their wealth and natural resources subject to obligation of promoting economic cooperation based on mutual respect, equitable exchange and principles of international law. State parties to eliminate all forms of foreign exploitation, particularly that practiced by international monopolies, so as to enable their people to fully benefit from the advantages derived from their natural resources. Next, Article 22 says all people to have a right to their economic, social and cultural development with due regard to their freedom and identity, and in the equal enjoyment of common heritage of mankind. Article 23 says all people to have the right to national and international peace and security. Article 24 says all people to have the right to a general satisfaction environment favorable to their development. Article 28 says every individual shall have the duty to respect and consider his fellow beings without discrimination and to maintain relations aimed at promotion, safeguard and reinforcing the mutual respect and tolerance. Article 29 says that every individual shall also have the duty to respect and maintain his parents, to serve his national community and not to compromise the security of his state, to contribute to the promotion and achievement of African unity, to pay taxes that are imposed by law, to preserve the territorial integrity of his country, among other duties. Now, we will discuss the African Commission on Human Rights. The African Charter established the Commission on Human Rights, and the Commission was inaugurated on November 2, 1987 and has its secretariat in Banjul, the Gambia. The Commission consists of 11 members elected by the African Union Assembly from experts nominated by the state parties to the Charter. Once elected, the commissioners serve in their personal capacity and not as representatives of their respective countries. The Commission elects its chairperson and vice chairperson as the Bureau of the Commission. It is this Bureau that coordinates the activities of the Commission and supervises and assesses the work of the Commission's Secretariat. The mandate of the Commission is listed under Article 45 of the African Charter. Article 45 states A. Carrying out sensitization, public mobilization and information dissemination on human rights through seminars, symposia, conferences and missions. B. Ensuring protection of human and people's rights through its communication procedure. Friendly settlement of disputes, state reporting including consideration of NGOs, shadow reports, urgent appeals and other activities of special rapporteurs and working groups and missions. C. Interpreting the provisions of the Charter at the request of a state party or an individual. Now, as seen in the case of Inter-American System, whereby IACHR is charged with receiving individual petitions for human rights violations, the African Commission is also tasked with a similar obligation. Though it's called a communication, this communication is one of the mechanisms whereby the Commission receives complaints from states against another state or by individuals and NGOs against one or more states on alleged violations of human rights in accordance with its mandate under Article 48, 49 and 55 of the African Charter. The most important aspect of this communication system is that any individual may bring a communication before the Commission. The African Charter is silent on the issue of standing and the rules of procedure of the Commission and does not provide for a victim requirement. Therefore, a communication may be submitted by the victim or anyone on their behalf as well. However, it must be noted that a communication can only be brought against a state that has ratified the African Charter and by no one else. Now, before a communication is admitted by the Commission, it must comply with the with certain requirements, which are 1. The author must have been indicated. 2. Must not be in a disparaging or insulting language. 3. Must not be solely based on media reports. 4. Domestic remedies must have been exhausted unless either the domestic procedure is unduly prolonged or rights claimed are guaranteed by domestic laws. 5. It must be submitted within a reasonable time after exhausting local remedies. 6. Issue raised must not have been settled under other UN or AU procedure. So, these were the requirements. Now, with respect to the functioning of the Commission, it must also be noted that once a communication has been admitted, the Commission may direct the state concerned to take one or more provisional measures pending the finalization of the communication. These measures are necessary to prevent the irreparable damage that is being done to the victim of an alleged violation. If the state fails to comply with the request by the Commission for the adoption of provisional measures after a period specified, the Commission may refer the communication to the African Court of Human and People's Rights. Let us look into its functioning and working now. The African Court on Human and People's Rights, briefly referred to as just the African Court, was established through a protocol to the African Charter, which was adopted in 1998 and only entered into force in 2004. The court was established in order to complement the protective mandate of the Commission. Its decisions are final and binding on the state parties to the protocol. This court consists of 11 judges who are elected by the African Union Assembly and from a list of candidates who are nominated by member states of the African Union, and those who serve the court for a period of 6 years and are eligible for re-election only once. Also, the court's jurisdiction applies only to states that have ratified the court's protocol. The court may entertain cases and disputes concerning the interpretation and application of the African Charter, the court's protocol, and any other human rights treaty that have been ratified by the state concerned. The court may also render advisory opinion on any matter within its jurisdiction. The advisory opinion of the court may be requested by the African Union, member state of the African Union organs, and any African organization which is recognized by the African Union. It must also be noted that individuals may directly petition the African Court as well. However, this feature of allowing individuals to approach the African Court has been diluted to a great extent by the court's protocol. Article 34, Clause 6 of the said protocol lays down that at the time of the ratification of the said protocol, the states shall make a declaration accepting the competence of the court to receive cases under Article 5, Clause 3 of the protocol. It further states that the African Court shall not receive any petition under Article 5, Clause 3 involving a state party which has not made any such declaration. This means that until and unless state makes a declaration accepting that individuals may also approach the African Court directly for human rights violations, individuals may not approach the court against the state. Now let us discuss the regional human rights system in the Arab world. In 1945, Egypt, Iraq and Transjordan, which is now known as Jordan, Lebanon, Saudi Arabia and Syria signed a pact to create what is known as the League of Arab States. Over the years, the number of members of this league has increased by a considerable margin. So much so that now their agreements generate considerable amount of discussion, and which is why it is important to learn about the system of protection of human rights as well. Now, the Arab Charter on Human Rights was adopted by the League of Arab States in 1994. However, none of the member states had ratified the Charter. Therefore, the Charter was later updated and led to the amended version by the Arab Summit in Tunis in 2004. The 2004 revision of the Charter, known as the Arab Charter on Human Rights, only entered into force in March 2008. Now, let's discuss the Arab Charter on Human Rights in a little detail. The Arab Charter contains a total of 53 articles, including provisions that put a positive obligation on the states to provide the very basic rights to its citizens, and on the other hand, it also puts negative obligations on the states to not to interfere with the lives of individuals. It protects a number of traditional human rights as laid down in the UDHR, including the principle of non-discrimination under Article 3, the right to life under Article 5, equality before law under Article 11, prohibition of any form of slavery, trafficking in human beings, and exploitation of children in armed conflicts given under Article 10. It also provides that every citizen has the right to take part in public life, to stand for election and choose his or her representative in impartial elections. This is provided in Article 24. Further, the Charter protects privacy of family, home and correspondence by giving it under Article 21. Another field where a significant improvement has been achieved is the administration of justice, given under Article 10, and the adoption of the agreed fair trial norms and principles under Article 16. The Arab Charter includes a general statement guaranteeing the independence of the judiciary and protecting it from interference, pressure or threat under Article 12. It enshrines the right to liberty and security of persons, prohibits arbitrary arrest and detention under Article 14. Torture and cruel, inhuman or degrading treatments which are considered as crimes not subject to any statute of limitations, and sets out the right to reparation for victims of torture under Article 8. It also prohibits medical experimentation without the consent of the persons concerned under Article 9. The Charter restricts capital punishment to more serious crimes under Article 6. It sets out the principles of legality of offences and penalties under Article 15. The non bis in idem principle is given under Article 19. The prohibition of imprisonment for civil debt is given under Article 18. And the humane treatment of persons deprived from their liberty is given under Article 20. In the other areas, the Charter innovates and appears to be ahead of other international instruments by enshrining the rights of persons with mental and physical disabilities under Article 40, and also by outlawing violence against women and children in the family under Article 33, Para 2 of the Arab Charter. By looking at these provisions in a very brief manner, it could be conclusively said that the Arab Charter is an exhaustive bucket of rights. Nevertheless, let us look at some of the critiques that have come with respect to this charter. The criticism of the Arab Charter is as follows. Now, the most important milestone that has been realized by this charter is that after decades of gestation, finally the Arab states have adopted their own binding instrument on human rights. Having said that, the Arab Charter has been widely criticized for multiple ambiguities and deficiencies in the formulation of its articles. Let us now discuss some of these. The foremost criticism of the Arab Charter is that it does not provide any effective mechanism for anyone to seek redressal whatsoever against the violation of his or her human right. All it does is create an Arab Human Rights Committee which is interested only to receive governmental reports by the state every 3 years on measures they have taken to give effect to the rights and freedoms recognized in this charter, and also on the progress that is made towards the enjoyment thereof. Thereafter, the charter provides that the committee shall discuss the report, comment thereon, and upon them make the necessary recommendations. Therefore, the charter ends up being a toothless tiger. Now, compared to the enforcement mechanisms provided by the European, Inter-American and the African systems, which have granted their supervising bodies the mandate to receive complaints from individuals, the solution adopted in the Arab Charter is the weakest and is indicative of deeply rooted distrust vis-a-vis an effective human rights system. Another criticism stems from the deficiencies in formulation of its articles. This is notably with respect to the right to equality between men and women, whereby Article 3 categorically recognizes the framework of positive discrimination established in favor of women by the Islamic Sharia. Further, the prohibiting capital punishment for those under 18 years of age, whereby it uses the clawback clause unless provided otherwise in national law. The wording of the preamble, which says rejecting all forms of racism and Zionism, which commentators argue equates Zionism to racism. From this discussion on the criticism, it is clear that the Arab Charter is a positive step forward in line with the international human rights standards. However, given the absence of an effective enforcement mechanism and lacuna in drafting of its articles, questions still linger as to the effectiveness of such a charter. Having said that, the initiative is commendable and must be strengthened further by actions of multiple stakeholders. With this, we end our discussion in this module. Thank you for listening.